So I will be moderating. This topic is exhaustion and copyright law, so we'll have a double dose, and I'll have an interesting, I think, intersection with the last panel's discussion. So to my left, immediate left, is Bart Lazar, who is a partner in the Chicago office of Seaforth Shaw. He counsels clients in copyright, trademark, privacy, security, and a host of other areas of law. He received his BA from the University of Chicago and his JD from our law school, and also received an LLM in trade regulation from NYU School of Law. He was the first recipient of Chicago-Kent's Distinguished Intellectual Property Law Alumnus Award, and he will be DJing at the Chicago-Kent Block Party this Saturday around 3 p.m. So come here to hear Bart DJ at the block party. And then further down to my left is Professor Chris Buccafusco, who is an associate professor of law here at our law school and also the co-director of the Center for Empirical Studies of Intellectual Property. He teaches torts and copyright law, and his research interests include intellectual property law, behavioral law and economics, law and psychology, and legal history. He received his BS from Georgia Tech, and here's the JD.
Georgia.
JD from Georgia, excuse me. And he also is completing a PhD in legal history at the University of Chicago, and he is at the forefront of behavioral economic analysis of the law and IP, and we're happy to have him on the panel. Okay, so just to give you a little bit of background about this case, for the students in the room, this case should be near and dear to your heart. The party involved was Supap Kirtsaeng, a Thai national who was living in the United States to get his PhD. And he had his family and friends back in Thailand lawfully purchase textbooks in Thailand, some of which were sold by John Wiley, the publisher. And they were made and published in Thailand by John Wiley. Now, Kirtsaeng then resold those books that his family and friends had sent to him from Thailand to the United States. Publisher John Wiley then sued Mr. Kirtsaeng for an unauthorized importation and distribution of his foreign edition textbooks in violation of what they argued was the U.S. Copyright Act. The Supreme Court, in an opinion by Justice Breyer, held that the first sale doctrine in the U.S. Copyright Act applies even to the copies of the copyrighted work lawfully made abroad, here, meaning here, John Wiley's foreign edition textbooks that were manufactured in Thailand, in addition to any U.S. manufactured books. So therefore, as a result of this understanding of the first sale doctrine, Kirtsaeng's resale of the foreign edition textbooks manufactured by John Wiley was perfectly legal in the United States. And that's how Mr. Kirtsaeng helped to finance his graduate studies here. Okay, so with that background in the case, let's get right to it. The lower courts for some time were in disagreement and almost into fits, trying to interpret the basic phrase in the Copyright Act 109, the Section 109 for the first sale doctrine, lawfully made under this title. And both the Second Circuit and the Ninth Circuit eventually agreed upon an interpretation of those words, lawfully made under this title, to import a geographical sense, that it had to be lawfully manufactured, the copyrighted work had to be lawfully manufactured in the United States in order for there to be exhaustion. So the Supreme Court seemed to, well, the Supreme Court did disagree with that geographical approach, and Justice Breyer said the most reasonable interpretation of the language of the statute, given its structure and the history of the first sale doctrine, means that lawfully made under this title means something more like lawfully made in accordance with the U.S. Copyright Act. So I guess my first question would be, did the Supreme Court get it right? Does that make better sense of the first sale doctrine and the Copyright Act? Yeah. Open up to Bart.
Sure. Thanks, Ed. I think it is close. There's two circuits both had different views, so it's a close call. But I think the court did get it right. They're looking at it, and you're talking about the international playing field, and looking back at the goals of of the 1976 revision of the Copyright Act. There's a lot of concern with piracy, and to the extent that, let's say if you looked at the law not applying overseas, and you had a foreign country that was saying, okay, it's lawful to make these works, and they were infringing, they were counterfeit works. Would our law, not apply at all to those situations? So I think you have an original, in the copyright law, you've got an original work, you've got a fixed and a tangible means of expression, and it's sold with the authorization of the author. Once it's sold with the authorization of the author's received its benefit from the copyright law. So they've been rewarded, and even if you go back to the purpose of the Constitution, and you go to the clause, you go back to Article 1, Section 8, and you say, well, the purpose is the progress of science and the useful arts. We're giving authors this limited exclusive right. And notwithstanding what the Supreme Court said in Eldred, where limited times can, as long as there's a limit, it could be hundreds and hundreds of years, there's still some limitation. So it gives some sense to a limitation, and it's not just a limitation of years, it's a limitation of actions as well. So I think they did get it right. Chris?
Yeah, so it's a complicated question, right? As Bart indicates. Most of this opinion is devoted to questions of statutory interpretation, right? So we've got these, various terms that exist, so going back to original common law opinions, right? In first establishing the first sale doctrine. The law even goes back, the opinion goes back to Lord Coke, this late medieval English lawyer talking about the alienation of chattels. Much of the opinion is about statutory interpretation, right? And because these are really good attorneys and really good justices fighting over this kind of stuff, when you read the majority opinion, you're like, yeah, that seems entirely right, absolutely. And then you read the dissenting opinion, you're like, yeah, no, that seems entirely right too. So you put in a kind of difficult, as someone who is not, as deeply involved in the legislative history of this, right? It's often difficult to say, right? Because again, much of this depends on the kind of dueling, statutory interpretation canons that are in play here, right? So we have, on the one side, so everyone has to play the original meaning statutory canon, right? So, the plain and original meaning of this thing is this and this and this, right? It imports a geographic limitation. No, the plain and original meaning is this one, right? So that's that statutory canon. In addition, there are other statutory canons, right? Like, we want to make sure that we read this part of the statute so that these words mean the same thing here that they do here, right? So, okay, let's find some different places where they use lawfully made under this title and try and read them together. Or we want to make sure, right, and this is one of the arguments of the dissent, right, we can't read this law, according to a different canon of statutory interpretation, such that what's happening in this importation ban provision, right, which is section 602, is basically meaningless. Right? So one of the things about statutory interpretation is we're not supposed to an interpretation of an ambiguous statute that results in that piece of the statute having basically no function isn't a good one, right? And one of the things that happens here is, and the majority admits this, the limitation on importation in section 602 shrinks pretty drastically. Okay, so previously, right, there was this notion that, well, any kind of importation of works from abroad was potentially barred, right? In an opinion prior to this one, in the Quality King case, the court said, no, that's not true, right? The first sale doctrine applies to those situations as long as the works are made in the United States, right? So if the works are made in the United States, then sold elsewhere and brought back here, the first sale doctrine applies. So that shrunk the 602 limitation pretty significantly. Same thing comes up again. Okay, so what about these things now not made in the United States, made abroad? Does that make a difference, right? And the court says no. So what then is left of section 602A? And the answer, the court's pretty obvious, pretty authentic about this. They say not an awful lot, right? A couple of situations in which, so take for one of the examples they give is, imagine you have a work, right, and you distribute that work to a printer abroad who is going to print it, and what the printer abroad does is circulate it, right? So it's a printer, not an owner, right? The printer prints the work and circulates it and imports it back into the United States without your permission. That would still be covered. Or, for example, if you license a copy of a film to be shown abroad and they attempt to import that copy back into the United States, that would be limited. So there are a couple of these things that will continue to be limited under the 602 importation clause, but they are pretty narrow. So trying to think about which of these dueling statutory interpretation questions is the correct one are difficult. In the concurrence, I think Justice Kagan kind of gets it right. I think she says, really the problem here, right? It seems like Congress wanted to do something here about importation of foreign works, right? Foreign produced works or foreign sold works. But we kind of took that away from them. Actually, she says, you guys took that away from them. I wasn't here yet, right? You guys took that away from them in your quality king holding, right? And so what you're trying to do now is to kind of get that back through the back door here in this case, in this Kirtsaeng case. And really, right, what you should do if you want this is to go back to that. And that's probably what Congress wanted to do. They just wrote a pretty ambiguous set of statutes to do it.
Yeah, one thing that seems interesting to me is that if you go back to the first sale doctrine, it started out, the Supreme Court recognizing it in Bobbs-Merrill, Congress codifying it, 1909 Act, or an earlier Act, 1909, 1976 Act, and they might have been just doing exactly adopting what the common law first sale doctrine was, which was focused on the sale and not necessarily manufacturing, place of manufacturing. But then Congress does come in with this importation right, which intersects with the first sale doctrine, and it's sort of like, how do you make sense of it? And I think you're right, maybe, that Congress didn't really work through that question that clearly.
Right.
And then it was sort of now back to the Supreme Court to take another bite at the apple. This is the third case in which they're interpreting this first sale doctrine under the 1976 Act, and Breyer comes out with a decision that's basically first sale anywhere in the world, authorized by the copyright owner, implicates exhaustion. Is that the bottom line? Pretty much?
Yeah, I think so. And I think, you look back at, Breyer was the dissenter in Eldred, where he stood up and said, you got to be kidding. You can't give copyright owners, you keep extending copyrights retroactively and giving longer and longer periods of time. So he's clearly out there, thinking about, okay, there should be limitations on copyright ownership. And now he's writing this decision. And I look at it exactly like that. He's really opening the gate.
Yep, so it seems. I think it's worth taking a second here to also make sure everyone understands kind of why people care so much about this, right? It wasn't always clear to me why I should care so much about this. So it's kind of, I think, worth unpacking that just a little bit, right? So what the publishers are trying to do here is to basically create price discrimination. They want opportunities for price discrimination in different parts of the world market, right? They want to be able to sell, to you rich American students copies of your textbooks for $250, and I know you're going, don't feel terribly rich right now, but at least you're capable of taking out very high numbers of loans, right? Unlike people, in the developing world who aren't, right? So what they want to do, what the publishers want to do, is they want to price discriminate. They want to charge you $250 for Epstein on torts, right? And they want to charge, people in the developing world, in this case Thailand, $50. Right? And that might be because it's valued less there. It might be because there are wealth effects that mean people can't pay as much there. Right? But that's what they want to be able to do. Right? But what you've got with someone like Kirtsaeng is what's called arbitrage. Right? He buys cheap and sells high in a different part of the world. Right? And he can make a lot of money doing that. Right? And so one of the things the court says, right, is, well, this is good. Right? This is good for you. Right? And I think a lot of you are probably happy with this, right? At least a lot of you who are students, right? And anybody who buys used books, right? This seems like a good thing, right? Your books are cheaper. The argument on the other side, though, is that you're capable of paying for books that are more expensive. There are other people in the world who aren't able to do this. If the result here is that this kind of geographic price discrimination goes away, the claim by Wiley and others is they're going to have to increase prices abroad. Right? If they know that there are a world full of Kirtsaengs who are going to be taking these books from Thailand and China and India and shipping them back here, right, the only way to make sure that they're not underselling their market here is by increasing the prices abroad as well. Right? So this is potentially bad. Right? I mean, this means that an access to knowledge more broadly is potentially limited. Right? That this opportunity for price discrimination is potentially a big problem. Right?
But will the market tame some of that? So, I mean, it happens the same thing with the pharmaceuticals. In theory, you could say you can charge for pharmaceuticals a very high amount in developing countries, but that usually doesn't happen.
Yeah, there's a lot of ways that the market can react to this. I mean, I think Chris's argument is a strong economic argument, but then you look at, well, gee, you can take the other side on the decision and say, look, if you look back to the Constitution, and the purpose of copyright is we're trying to progress science and the useful arts, right? So if you look at it from the decision, by bringing books into the United States, well, maybe it makes sense if the product is already in the United States, well, then it should be sold. But the thought could be, well, what if a copyright owner decides not to sell a product at all in the United States? It wouldn't progress science and the useful arts if a copyright owner wouldn't allow the importation of this work. It would keep a work. I mean, it might be in the Library of Congress, but it may not be out there in publication. But then look at it from the other side, with the Supreme Court making this decision and listening to Chris's economic argument, is that potentially the progress of science and the useful arts doesn't overflow internationally because now the prices have to go up and there's less of an access to educational works overseas. But the market can react, and I think the market could react to a print-to-send type of model where, if I can't sell my books at a lower price, I might just adopt I'm not going to sell physical textbooks. I'm only going to license textbooks. You can have to download them. You're going to have to click off a terms of use, and if you're going to get that work, you can only get one, and you can't do anything with it. Now, that might be violative of the decision. The second would be to try to, copyright owners or owners of works are creative. We could try to, textbook owners could potentially create a second-tier quality product for foreign markets. Poor bindings, different fonts, different kind of, and sell that at a lower price and say, well, this is intended only for this market, and then the quality of that work would be different, and then you might be able to prevent importation on the basis of trademark law.
Okay. I'd like to turn now to a slightly different topic and sort of the interplay of this decision with other types of intellectual property. So just to give a little bit of a background, the prior case that the Supreme Court split 4-4 was Costco versus Omega, and they were equally divided in 2010, so that precedent, well, the case doesn't have any precedential value. In that case, it involved Omega watches and the tactic of Omega placing a small insignia on the back of the watch to claim that it was copyrighted, to invoke the then more favorable, more protective interpretation of the first sale doctrine that would have been basically national principle of national exhaustion in order to sort of compensate for the less protective law of trademark that basically would amount to something more like international exhaustion. Now with the Kirtsaeng decision, what is the strategy for brand owners who are trying to get protection from international exhaustion? Is there a way for them to come up with some strategy to engage in market differentiation?
Yeah. Well, I mean, I think Bart's suggestion is an interesting one, right? Presumably, if you're the logic of having a kind of trademark-related claim here, if I'm not mistaken, right, is that maybe I want to sell some sets of products in one market with certain kinds of qualities, right, different sets of products under the same mark in a different market, right, with different sets of qualities, right? And what I'm concerned about is when products from my lower quality market are coming into my higher quality market, right, they're gonna upset people's assumptions and understandings about the quality of my mark in my high quality market, right? So this is why trademark law can prevent others from importing those goods. So this notion that Bart has suggested of the possibility of kind of creating inferior products, right, calling those special products for those markets, and then relying on trademark law principles, right? Wiley Asia is a lower quality good than Wiley America or Wiley Western Europe, and thus trademark law allows us to ban those importations.
Yeah, unless it's not a totally fictitious action, the point is you have a material difference in a product. So the case law is, for example, in the shampoo area, you created a product for a market or soap, that has a different scent for a different market, or it has a different composition for a different market, and so there's legitimate reasons. So I'm not actually saying, I mean, yes, we could use the term inferior, but it really would mean it's a materially different good. And to sort of meet the economic needs of a foreign market where people can't afford that high quality product, maybe that textbook does need gold embossing. Maybe that textbook has a different font. I mean, it's possible that at people in foreign jurisdictions are more agreeable with other fonts. Calibri instead of New Times Roman or something like that. So I think there's a lot of variety. I don't know if it's if that's something that's going to play out, but it's something that I would certainly consider. Of course, the costs of manufacturing two versions or multiple versions of one item, may usurp the value for a profit-making company. That I don't know.
So on remand in the Omega Watch case, the district court found that tactic of Omega was a copyright misuse. And that's on appeal right now to the Ninth Circuit. I should disclose that I've written an amici brief in support of the district court judgment. If the scenario that you suggested could happen under trademark, should that be a trademark misuse? If rights owners try to evade the copyright for sale doctrine by changing the material of their publications?
I don't think so. If there are legitimate reasons for it, if there's legitimate
some people prefer
well, it has to be the market only dictates a lower quality work, or work that maybe we don't need a textbook sold in a foreign jurisdiction that needs to last for a lifetime. Maybe it only needs to last for 2 to 5 years because the translation of the book is going to be different. Why do we have we used to always have pocket parts in these books that would be updated every few years, and those are certainly lower quality printed items. And I think if it's very minor, if it's a very subtle difference, like okay, we changed the paper. The paper is different. In the United States, we're using this one paper, and we're using someone else's paper, and there's no real justification. One, that wouldn't be a material difference, and two, I don't know if there's some kind of underlying legitimate justification for it. Chris, I don't know.
No, I have no idea, right? Like, I mean, at least I think I can understand the trademark-related reasons for that, right? Like, I mean, if I try to think about whether that is consistent with some general principles of trademark law, I think I can come up with some. In a way that I think it's harder to come up with general principles of copyright law that support these things. This is one of the interesting things that the court says here, right? So the majority opinion, in hearing these arguments about how, right, so after they do all of this stuff about statutory interpretation, then they get to, well, is this a good thing or a bad thing, right? And so on the one side, they've got a number of libraries, museums, and others who are deeply concerned about importation limitations. And on the other hand, it's the publishers who say, well, we want to be able to price discriminate geographically. And the court says price discrimination is not a, how do they call it, a basic principle of copyright law. Or we can find no basic principle of copyright law which supports the notion of price discrimination, which is kind of an interesting thing for the court to do, right? Perhaps I'm overly sanguine, and I think both Bart and Ed have started to convince me that I am. I'm wondering if this is perhaps some effort by the court or by certain members of this court, Justice Breyer especially, of trying to read back into the Copyright Act kind of stronger teeth, right? That the Article 1, Section 8, Clause 8, and general philosophical principles about what copyright law should do are going to have meaningful constraints on what Congress can do under its copyright clause power, right? As they're saying here, we don't see anything in our understanding of what Article 1, Section 8, Clause 8 does or means to do or tries to support that gives us any reason for thinking that this is something it cares about, right? So it seems to be a kind of, at least maybe a more thorough interrogation of Congress's justifications for certain kinds of copyright-related activity than one might have seen in previous cases. But again, I'm probably far too sanguine about that.
And remember, the gray market is huge. It's a really big business in this global economy where you can take advantage of price differentials to import and export. Sometimes it flows more towards the United States. Sometimes it flows outside of the United States. And so creative owners are going to try to play with whatever rules they can to stop the gray market flow. And creative businesses are also going to try to take advantage and make money because there's a lot of money to be made. I remember the first case that I tried involved footwear. And we were trying to stop a company from importing legitimate footwear that it bought overseas. It was a trademark case. We couldn't do that. You couldn't stop it. There weren't any material differences. So what did we find? We found that this gray marketeer utilized our copyrighted catalog and cut it up into pieces and photocopied it and used it as his sales sheet. So we sued that gray marketeer doing everything legitimate in terms of the sale of the trademark goods. We sued on a copyright theory and won.
Good stuff.
Yeah, exactly. Good strategy. Do you think copyright owners can just start shifting to licensing their works? Renting their textbooks out to students? I mean, some may be doing that already.
Yeah. I mean, it's the original principle of Bobbs-Merrill, right? I mean, Bobbs-Merrill says there's no contract between these parties, right? If there were a contract, well, all bets are off, right? So certainly one can continue to attempt to do via contract what you can't attempt to do via the first sale doctrine. I mean, obviously, that's a lot of the market for goods these days, right? I mean, almost all software is licensed rather than sold. My guess is, I don't know, does anyone here have a digital textbook? They definitely circulate digital textbooks. Anyone ever read the end user license agreement? Did you buy a copy or did you license a copy? Right. So I'm interested. I don't know what the answer is. I mean, it might be that the answer is already out there as to what they can do. And the other.
Do you think that'll be attractive though? Do you think that's a
sure? And I mean, the other price discrimination mechanisms, right? I mean, it's kind of like your material difference one, right? But DVD country codes are basically the same kind of thing. Right? So the reason why if you buy a DVD in England or in Tokyo, it doesn't work here is because there's basically software installed on it that prevents it from running on your DVD. That enables them to charge a different price for it in those places than they charge for it here. Harder to produce country codes for textbooks currently, but not once things start shifting digitally.
Bart, what is your view? I mean, do you think some of your clients or prospective clients licensing works will be better?
I think so, because it is as Chris says, and we know it's accepted in the software industry and it's accepted on the internet. We've got, click wrap agreements are enforceable. So I'm not as familiar with enforceability in Thailand. So maybe that would be the situation where we would be able to stop the importation. In a licensee, someone takes a license and then reproduces it for sale and tries to import them in the United States. That would be one of the threads remaining. So I think it's a model that that publishers may well try.
Okay. So this case seems like a big boon for gray marketers, and obviously, as Chris mentioned, the copyright owners have a strong interest in market differentiation. Given the powerful copyright lobby, do you expect that Congress will revisit this and potentially go back to what some courts had recognized, a principle of national exhaustion that had allowed market differentiation? And would that be a good thing if so?
I think they will definitely try. I think there will be a try because there is a dispute in the copyright world. Each country has the right to decide whether or not it follows national exhaustion or global exhaustion. So even under the treaties that we're participating in, we have the right to decide. So I would definitely think that copyright owners will push for it.
Yeah, possibly. I mean, I guess the other question is whether it's really that big a deal in a kind of world that continues to shift more towards licensing, right? And publishers of dead tree books will care, right? It's not clear that publishers of other kinds of materials will care. And if upcoming copyright legislation becomes more more contentious than previous copyright legislation has been, perhaps this is one of the things that they decide to let slide. Mm-hmm. Who knows, right? It's just tough to predict the strategies.
Okay. We have a few minutes left. I just wanted to open it up now to the audience for questions. Does anybody have a question back there?
Thanks, professors, for your discussion. To your licensing strategy argument, it sounds like at some point it'll have to be not even a license to a work, but a license to a service, because this first sale doctrine, I don't know how it would apply digitally, but I would like to point out the example of Netflix in Australia right now, that they're getting charged ridiculously more. They don't have options outside of Netflix or Hulu. They get charged more, such that for IT or software that they download to their computers, it would be cheaper for them to send somebody from their company in Australia to America, buy the software, and take it back than it would be to directly get it. And so countries like Australia are going against WIPO, and they're saying, look, we understand our citizens are being ripped off here. And they're encouraging people to use virtual private networks, which it's like when you sign in from home, but you're working on your work computer, so you're not at your protocol, your IP address that you would be at work, but you're still into that network. The reason I bring this up is because that violates the terms of service that Netflix has, which goes against the Computer Fraud and Abuse Act. So we're committing misdemeanors right away if we violate the terms of service of a website, and if we do it intentionally, then we've committed a felony. And we're doing this to save ourselves money because we know we're getting ripped off by the people who are creating the terms of service. I might have gone on more of a rant than really asked a question. However, I would just, talking about licenses, that's really the interest, especially with price discrimination, because there's these legal controls, but they're not the only controls on the market. There's also these business controls. So how do you address the outside regulators of this legal issue? Or answer any way you want. This is just a general rant.
It's a very good rant and a very good question. I have nothing to say about the rant other than, it's a potential problem, right? Some of these are the kinds of things that might be subject to, deeper markets could help solve these problems. Maybe they can, maybe they won't, right? I'm not sure what the Australian market looks like in terms of its depth, and if that's why, Australian consumers pay more than do American consumers. Right? I guess, on the other hand, I'm kind of okay with at least Australian consumers paying more than consumers in developing parts of the world for those same services. At least if that's not based on kind of market limitations, but rather on things like willingness and ability to pay. Right? So teasing those out is an incredibly difficult normative question.
Yeah, I think you're pointing out to the issue that there's, this may be a minor footnote in the first sale doctrine in what is really has to go on in global copyright today, with people thinking, look, when the first copyright laws were enacted, they were, decidedly out of date. When I was going to law school here, I wrote a copyright paper on, the satellite interception of football TV programs in blacked out cities. Like that was a big hot issue, in the late 80s. Stuff is blown out of the water. At that time, that was the 1976 copyright law was out of date. The DMCA was out of date the minute it was printed. We just can't keep up with, the laws can't keep up with practice or technology, and it's both people need to understand that we have to, copyright should be protected, but then, how should there be such huge penalties, both criminal and civil, for some of these some actions?
Great, thank you. I think we're out of time, so why don't we thank our panelists for their excellent discussion.
Thank you.